You're good to go, Gladys.
Okay.
Just want to know how many we are now. Oh, still 9. Okay. Never mind.
Recording started, Gladys, whenever you're
Okay.
ready.
Okay, my love. Okay. So I would like to welcome everybody. Today is Wednesday, November 22nd, 2023, 9 Kislev 5784. Welcome all to our most informative session by our wonderful speaker, our friend, Maître Alain Murad. My name is Gladys Perez Moalem, coordinator of Women Learning Group, a program created by our previous Rabbi Shahar Orenstein 14 years ago, following a ladies' bat mitzvah celebration on July 5, 2009. Our topic today is marital regimes in Quebec, with a focus on the rights of unmarried cohabiting couples that we all need to learn about. Our next Wednesday speaker is our new Rabbi Yoshua Ellis. He will teach us about a topic of his choice, and wish happy Hanukkah to all. I invite Sandra Kuku to read for us a short biography of Maître Alain Murad. Sandra Kuku, bevakasha, bechavot.
Good morning, everybody. Alain Murad is Vice President, Legal and Secretary of Canadian clothing retailer Reitmans Canada Limited, where he oversees all of the company's legal requirements. Prior to his time at Reitmans, Alain was a partner in the Montreal office of Davies, Ward, Phillips, and Weinberg LLP, practicing as the corporate commercial, intellectual property, information technology, advertising and marketing, and privacy law fields. Alain also practiced in the Montreal office of Borden Ladner Gervais LLP and with the Boston-based law firm Testa Hurwitz and Thibault LLP. Alain is a graduate of McGill University's faculties of law and management and Concordia University's faculty of commerce. Alain also served as a law clerk to the Quebec Court of Appeal and is a member of the bars of Quebec and Massachusetts. Back to you, Gladys.
Thank you, Sandra. Maître Alain Murad, bevakasha, bechavot.
Okay, thank you very much. So good to be with you, as always. You had requested that I provide you with a presentation on marital regimes and specifically focusing on the rights of cohabitating couples in Quebec. What rights do unmarried couples have in Quebec? So it's an interesting question, and there's a fair amount of information to cover. Before I focus on the rights of cohabitating couples, I'll just say a few words on the nature of marital regimes in Quebec, because it does provide a certain background insofar as sort of delineating, what the rights of cohabitating couples are. So, marital regimes and in Quebec. When two people get married, there are certain rules that apply to them. And those rules are largely determined, not entirely determined, but are largely determined by the choice of their marital regimes. Couples can choose their own marital regimes. A marital regime or a matrimonial regime sets the rules for managing the property and debts accumulated during the marriage and how they will be divided up in the event of a divorce. So when two people get together, they get married, they choose a marital regime. And the rules of those marital regimes will essentially determine what happens if the couple splits up. What happens, to the income that was earned during the marriage? What happens to certain assets? How are they divided? Now, different marital regimes have different rules concerning the rights and powers of the spouses. If like me, when you got married, you signed a notarized marriage contract in front of a notary. Your marital regime is the one stated in the contract. Okay. If you did not sign a marriage contract in front of a notary, or if your marriage contract doesn't mention a matrimonial regime, then your regime will depend on when you were married. Now, there are three main marital regimes in Quebec. There's partnerships of equests, which is if you were married on July 1970 or later and you didn't choose a marital regime, you fall under the marital regime of partnership of equests. If you were married before July 1st, 1970, and you didn't choose a marital regime, you were under community of property. And if you went to a notary and you mentioned the marital regime, it's likely that you mentioned separationist of property. I'm only going to focus on the first two because those are the two most sort of current and relevant for our purposes. Now, before we get into a discussion of marital regimes, it's important that you understand the concept of the family patrimony. So the family patrimony is a very, very important set of provisions in the Civil Code of Quebec. And these are what are termed imperative provisions of public order. In other words, you cannot contract out of these provisions. They will apply to you no matter what. Even if you have a contract that says they do not apply, a court will nevertheless make sure that they apply in the event of the dissolution of the marriage. Okay? Family patrimony provisions are imperative provisions of public order. You cannot derogate from them. Okay? Society deems them too important. And the reason why they are deemed so important is because historically, people who got married and then subsequently divorced, it was often the case that one of the spouses was left in a state of penury, of financial indigence. They didn't have money. They were poor. So these provisions on the family patrimony essentially try to, ensure that when the marital regime dissolves, neither of the spouses is left in a state of indigence. Okay, so what is the family patrimony? This is something, again, distinct from the marital regime that you choose, and again, it applies no matter what. The family patrimony consists of those really chunky, valuable assets that people own. Primarily, people's wealth resides, for example, in their family home. So, speaking for myself, I own my home in Côte Saint Luc, and that's really the bulk of my where my wealth lies is in the value of my house, and that's true for the vast majority of people. Most of their assets, most of their financial worth resides in the home. Okay, so their primary residence, their secondary residence, if you're fortunate enough to have a country house or a vacation home, vacation condo in Florida. There's furnishings, decorations, art, furnishings, decorating the family. Yeah, it is art. It does include art. And the cars, if you own a car or a motorhome, and RSPs and pension funds. So you can see how the state essentially carves out these big assets and says these are always going to be pooled. They are going to be divided at the time of dissolution. And it's very, very important to keep this in mind when we get into a discussion on the rights of cohabitating couples. So what's not included in the family patrimony? Well, certain inter vivos gifts, shares in the company, inherited properly, that's always yours, no matter what. If you can keep it separate and you can clearly define it, that's going to be yours if the marriage dissolves. Property that would fall into the family patrimony that belonged to you if you If you received it from someone else, from a family member, you kept it separate. If it was gifted to you before you got married, if it was gifted after, all of these things, if they're commingled after the marriage with other family patrimony property, then the accrual and the value is pooled and split at the time of divorce. So, for example, if a couple gets married and one of the spouses has $1 million home going into the marriage, and that was gifted to him or inherited by him, and the spouse, they get married, and the other spouse, then the marriage dissolves, and at the time of dissolution, the house is worth $1.5 million. So the accrual in value would be $500,000 since the time of the marriage. So the spouse who didn't own the house would be entitled to $250,000, half the value of the home. So the family patrimony is divided equally between the spouses, okay? And the value of the property not included in the family patrimony will be divided according to the rules of the marital regime. And again, it's different depending on the nature of the marital regime. I'm going to stop here. Does anyone have any questions? You guys still there?
Remember, you're muted.
Partnership of bequests. Yeah, good. Okay, so partnership of bequests. Again, this is one of the marital regimes, one of the main marital regimes in Quebec. And I know the rules governing sort of the pooling and the dissolution of the pooling of assets after the dissolution of marriage. They're complicated. It's hard to sort of figure out, well, what falls into the patrimony, what falls out of the patrimony, what's pooled, what's not pooled, what the accruals and values are. These are things that family lawyers do when they preside over divorce hearings, and this is what judges adjudicate when couples divorce. So partnership of bequests is one type of marital regime. It's one of the main ones, and it's the default regime. So if you didn't choose separation as to property, you fall under partnership of bequests. Okay, it's really the default regime in Quebec if you were married on or after July 1st, 1970, if you don't choose a marital regime. And the regime is made up of two categories of property. There's the private property and there's the equests, which is property acquired during the marriage that's not private property. Okay, so remember, there's the family patrimony, and here you have private property, and then you have equests. So you have sort of these three categories of property now. So in this regime, the value of the property accumulated is partitioned or divided when the marriage is over, but it does not include private property, unless the private property is family patrimony, in which case there's a pooling and the accrual and value is divided. See how complicated it gets. So private property acquired before marriage is inherited property, gifts, previous rights to support, disability payments, insurance proceeds. All of these things, all of these are private. And then equests are property which is acquired during the marriage that's not private property. And the big one is salaries and investment. Okay? So if you're not married, if you don't choose to get married under separation as to property, and one of the spouses makes $1 million a year, and the other spouse makes $50,000 a year, at the time of dissolution of the marriage, those salaries, which are not family patrimony, would get pooled. They'd get divided. So that's really the big chunky thing about partnership of bequests. And that's why I always recommend to people that they get married separate as to property. Because the state says that certain things you can't get out of, right? You cannot get out of the family patrimony provisions. So your house is going to be, pooled and divided. Your RSPs during the marriage pooled and divided. All that amount is going to get pooled and divided. So what's left to you? Well, things that don't fall into the family patrimony are salaries and investment income, right? But if you don't choose separate as to property, even that will get divided. So I always say to people, marriage is not a vehicle to loot other people's wealth. So protect yourself as much as you can. Marry separate as to property. The only time it ever matters is if the marriage dissolves and you're on bad terms, right? And if that's the case, you're not going to want your salary and investment income to be pooled as well. It's complicated, and I know that, so this aspect of family law is not something that's really intuitive or simple. So what's separation as to property? Well, this marital regime tries to keep people separate, tries to keep their income separate, tries to keep their salaries and investment income separate. Again, it doesn't touch the family patrimony because that's imperative, but separation as to property gives you some advantages, okay? You have to go to a notary, you have to get a marriage contract, you have to elect for this regime because partnership of bequests is the default regime, okay? So each spouse is independent under this regime. A spouse can manage, use, and dispose of their property without the other spouse's consent. Each is responsible for their own debts, okay? So unlike partnership of bequest, the property accumulated during the marriage is not partitioned or divided. Again, the only exception, family patrimony assets are always pooled and partitioned, okay? So the family patrimony applies to all married couples. It must be partitioned, but under separation as to property, there is a certain autonomy which a couple can enjoy over the ownership of their assets and the responsibility for their own debts, okay? Now, why is all this so important? Because this brings us really to the, the important aspect of our discussion on de facto unions, is because we're going to see that in Quebec, de facto spouses that are not married, but have been, for example, cohabitating with each other for many, many years, that may have children together, are not entitled to the benefits of the family patrimony, are not entitled to the benefits of spousal support, are not entitled to the benefits of compensatory allowances. So this is very, very critical, and there's very fundamental cultural reasons why the situation in Quebec is different from, say, the situation in Ontario. So now that you know something a little bit about the family patrimony, partnership of bequests, separation as to property, let's look at de facto unions in Quebec. So a common law relationship is when two people make a life together without being married. Okay, you just live together. Or even you don't live together. You might have kids together. Excuse me. Quebec law calls these couples de facto couples or de facto unions, right? In Ontario and common law Canada, they're called common law unions, common law relationships. Now in Quebec, there's an interesting statistic that Quebecers are nearly twice as likely to choose a de facto union over marriage than other Canadians. And in Quebec, I saw this statistic. I don't know if it's accurate. I think it's low. I think the figure is much higher than that. I would say it's at least half live in de facto or common law unions, okay? You don't always have to live together to be considered a de facto couple. But typically couples who are considered de facto couples live in the same home, right? They sit in the same home. They often have children together. So a couple can live together without being married, even if they have been together for 1 year, 3 years, 15 years, 40 years. And even if they have several children together, they are not automatically married in Quebec. Okay, they are not considered married in Quebec. So just imagine a situation where you have a couple living together for 40 years. They raise 3 children together, right? They live all this time together. They do everything a family does. They do everything a married couple does. they are in effect, they look like they're married, they act like they're married, but they're not married. And if that couple ever splits, then the spouses are really on they could be disenfranchised. No one's going to get what the other party's property. So in Ontario, it's a little bit different. And I have a couple of slides at the end discussing Ontario, okay? But it's very often the case that couples that live together for very protracted periods of time and have children together think they're married, but they're not married, okay? Sometimes certain government agencies will define what a de facto couple is for a very limited purpose. So, for example, Revenue Quebec might say, well, you know, for whatever tax purpose, the de facto union, they had to have lived together for 12 months in a conjugal relationship or have had a child together. But again, officially, they're not married in Quebec. So if they break up, they do not benefit from the protection of the family patrimony. So if one spouse owns the house, the other spouse can't get half the house. The spouse that owns the house gets all the house, okay? Don't have a right to division of property. If one spouse owns all the property, the other party doesn't own any of the furniture, that other party doesn't get any of the furniture. Compensatory allowance, a lump sum payment for work done over the years, for giving up your career, for taking care of the children and the house, you don't get anything. Support payments, spousal support. I haven't worked for 40 years. I gave up my career. Can I get some money? Nope. No financial support. That's different from child support payments. Those are different. That the parents are always responsible for child support, and it depends on their income. I'm talking about a spousal support. A will, if you die intestate, right? And you're governed according to the rules of intestacy. Remember my last presentation, we discussed this. If you're not named in the will, you get bupkis. Okay? This is the situation in Quebec. Where does this situation come from? Well, this is a long and sordid story. You have to understand that culturally in Quebec, for decades and even centuries, the Roman Catholic Church held enormous sway over the cultural evolution of the province. Okay? And historically, to live together and to consummate your marriage to consummate your relationship without being married was considered a sin. So Quebec never wanted to sort of reward people for living in a state of sin, right? Because you're living with a person, you're sleeping with a person, you're having children with a person, but you're not married, and you have this penumbra of religious influence and culture hanging over you. So Quebec culture, they wanted to encourage people to get married. So one way of discouraging them from not getting married is to say, well, you don't have all the rights of a married couple. So that's in the background. You have decades and centuries of culture, you know, telling you, you know, even that's certainly not the case now. It's no longer the case, which is what makes this particular case governing, you know, basically being the seminal case on de facto unions in Quebec so interesting. In 2013, that's only, you know, 10 years ago, there was a famous case called Eric versus Lola. Okay? Now, Eric and Lola were not the actual names of the people involved. And they used these names because they had young children, and there are sort of laws in Quebec that want to protect the identity of young children. And so in these contentious family law disputes, they use these pseudonyms. Does anyone know who Eric and Lola are? He's a very, very famous and wealthy man, Eric. I'm not hearing anything.
I want to know.
You want to know? So nobody knows? Eric.
Yeah, it was a famous case. I think the lawyer was Goldwater.
I'm not sure who the lawyer was, but I'm asking who Eric was. Does anyone know who Eric is?
I'm trying to remember, but it was in the news a lot.
Yeah, this was a huge, huge, huge thing 10 years ago. So Eric is a man by the name of Guy Laliberté. Do you guys know who Guy Laliberté is?
Yeah, I figured.
He is the founder of Cirque du Soleil.
Yeah.
Okay. One of the wealthiest men in Quebec, one of the wealthiest men in Canada. He's worth several $1 billion. And Lola was his wife, who I think was around half his age. So Guy Laliberté and his wife battled it out in front of the Supreme Court of Canada, because his wife, they lived in a common law relationship. She was not married. They were not officially married, and they split up. They had 3 kids together. They were together for years. They lived together, acted like a married couple. But when they split up, Lola was disenfranchised. She didn't get hundreds of millions of dollars, which she otherwise could have potentially got. So let's look at this case. This was back in 2013. The Supreme Court of Canada issued a ruling on the rights of de facto spouses, upholding the constitutional validity of the Articles of the Civil Code of Quebec, which provide that the support obligation, spousal support, and the division of the family patrimony, right? Family patrimony apply exclusively to couples who are married and not de facto spouses, thereby leaving Quebec civil law unchanged. In the absence of an agreement to the contrary, de facto spouses in Quebec cannot, upon the breakdown of their relationship, claim spousal support or the division of property that is owned by one of the de facto spouses only, regardless of the length of the relationship or whether they had children. Isn't that astonishing? Again, child support is something different. That's determined on the basis of the type of custody, the parent's income. There are specific guidelines governing how much money has to be spent on child support depending on the income. But all that other stuff, she got nothing. So let's look at the case in a little bit of detail, because it's a fascinating case, and it really brings to light sort of the broader cultural influences that give rise to this decision. So they met in 92. She was 17 and he was 32. I think she was Spanish or from a Spanish-speaking country. I'm not exactly sure. She was living in her country. She was pursuing studies. He finds this beautiful girl. He's 32. He's already, CEO of Cirque du Soleil, already making a ton of money and developing this incredible business. They're traveling the world together, right? They're living the life of Riley, right? 2 more children, a child, and she becomes pregnant in 96. They have kids, 99, 2001, 3 kids, and living the life. So Lola says, let's get married. Eric says, nah, I want to get married. I don't believe in marriage. Wow. They get separated in 2002. So I guess that's 10 years. They lived together for 7 years. So Lola is getting bupkis, right? Files a motion with the Superior Court seeking sole custody of the children, child support, and here's the kicker. She annexes a notice to the Attorney General of Quebec that she is going to contest the constitutionality of several articles of the Civil Code so that she could obtain the same legal regime benefits that apply to married spouses, namely spousal support, lump sum payment, division of the family patrimony, and a partnership of bequests, and the reserve of her rights to claim a compensatory allowance. Well, all of a sudden, the Attorney General of Quebec is involved because all of these provisions in the Civil Code are now suspect. She's challenging the constitutionality of these provisions in the Civil Code that say only married couples have a right to spousal support. Only married couples have a right to the division of the family patrimony. Only married couples have a right to the bequests of the other party. Only married couples have a right to compensatory allowance. So, judgment rendered in 2009, the Superior Court, the court of first instance, says, no, Lola, these are constitutional provisions. The provisions of the Civil Code did not infringe upon the right to equality. Plaintiff Lola did not succeed in showing the distinction made in the Civil Code between de facto spouses and married spouses had any substantively discriminatory effects. That's what the court of first instance says. Lola loses big time in first instance. On appeal, she appeals to the Court of Appeal of Quebec. The Court of Appeal says, well, you know what, Lola, you have a point. That Article 585 CCQ relating to spousal support was declared to be of no force or effect and unconstitutional. It's in violation of our rights of equality under the federal charter, and so you're entitled to spousal support. But they confirmed the previous decision to the effect that the provisions dealing with the residence, patrimony, compensatory allowance, and partnership of bequests were constitutional. But she comes out a bit of ahead because now she can get a big income, right? Guy La Liberté, billions of dollars. She can get a huge spousal support payment, right? So she wins on the spousal support. She loses on the patrimony and compensatory allowance and the bequests. But you get the sense that the Court of Appeal was looking for something to give this woman who had spent a number of years with this guy, gives birth to his children, taking care of the home, right? They want to give her something. They're throwing her a bone. Well, you get spousal support. So Guy La Liberté, Mr. Eric, says, hey man, this ain't right. We're appealing the Court of Appeal's decision on the constitutional validity of the decision, on the appeals, the constitutional of the decision on the invalidity of Article 585. And Lola's appealing the ruling, upholding the provisions relating to the division of property. So each one is doing their own appeal. Eric says, no, 585 is constitutional. And Lola's saying, no, the other provisions relating to the patrimony and compensatory allowance that were declared constitutional are unconstitutional. So they're both trying to get everything, right? So I'm not sure if you're following, but each one is basically trying to, further their own. It's an all or nothing approach that each one is taking. What does the majority of the Supreme Court say? Supreme Court reverses the Court of Appeal's decision on the invalidity of 585 and upholds its validity. So basically, Eric gets a big win. He gets a huge win. Whatever the spousal support benefit that was declared unconstitutional and should apply to de facto spouses was declared constitutional. Okay. So the support obligation, division of the family patrimony apply exclusively to couples who are married or have entered into a civil union, not de facto spouses. Sorry, Lola. Quebec law is fine just the way it is. In the absence of an agreement, to the contrary, De facto spouses cannot, upon the breakdown of their relationship, claim spousal support or the division of property that is owned by one of the de facto spouses, regardless of the length of the relationship or whether they have children. So basically, the bottom line, Eric scores a big, big, big win. He has to give her child support, but she doesn't get the tens or hundreds of millions of dollars that she would otherwise have got. You gotta be married. So what's interesting is the dissent. Now, Rosalie Abella, I don't know if any of you are familiar with Rosalie Abella. She's a Jewish jurist from Toronto, from Ontario. And she was on, I think she was on the Ontario Court of Appeal. She was appointed to the Supreme Court. And she is what some may term as an activist jurist. In other words, she wants to sort of impose what she thinks is right and not really necessarily what the law says. So I remember we had a discussion about judicial philosophy a few, I don't know if any of you were there, about sort of judicial restraint and activist jurists and people who are traditionalists. They don't want to reinterpret the law. They want to simply apply the law the way it's written. In any event, Justice Abella is a very sort of activist jurist, and she's of the opinion that the outright exclusion of de facto spouses from the Civil Code of Quebec on spousal support and the division of family patrimony constitutes a violation of the right to equality under 15.1 of the Canadian Charter, the federal charter. Says every individual is equal before and under the law and has the right to equal protection and equal benefit without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. And she would read in marital status. So she would say all of Quebec law is in violation of 15.1 and should be of no force and effect. So if she were in the majority, she would have given Lola a huge win. But she was in the minority. And she basically argues why marital status is sort of an analogous ground to all of these other prohibited categories of discrimination, right? I won't get into sort of the reasoning because it's going to get a little bit heavy, but there it is. So what's the conclusion? The result of this lengthy judicial saga is that the status quo in Quebec is maintained for the de facto spouses. In the event of separation, there exists no right to spousal support or to the division of property. All right. Now, the division within the Supreme Court reflects the division of opinion among Quebecers on these issues, particularly with the right to claim support for de facto spouses. But it is currently the responsibility of de facto spouses to determine the legal framework which will govern their relationship. So if the de facto spouses get nothing, how do they protect themselves? Well, there's a way. And it's through the law of contract. De facto union couples can enter into a contract called a cohabitation agreement. This is a written agreement between two people who live together in a de facto union that sets out their own division of property rules. A cohabitation agreement sets out various financial parameters of their union and what each spouse's obligations are in the event of separation, divorce, incapacity, or death. So, for example, you're in a de facto union, you don't want to get married. Well, look, I'm afraid that if we're together for 20 years and I'm taking care of the house and you're working and I'm giving up my career and we split up, I'm going to get nothing. So how do I protect myself? I enter into this cohabitation. This is what you're responsible for. This is what I'm responsible for. This is what I get if our relationship breaks up. This is what you get. This is who gets the house. This is who gets this. You're free to contract on your own terms, right? How are you going to share the day-to-day financial responsibilities? We'll split the kids' school. Okay, you pay for half the private school, I pay for half the private school. But if I'm paying for all of the private school, you have to make up for it in some other way. Whether one spouse will be able to represent each other. So, you know, we did a discussion on wills last year and mandates in the case of incapacity. What happens if I'm physically disabled? Are you going to take care of me? Do you have any obligations? You can impose contractual obligations if the person agrees, right? What happens if we separate or divorce? What happens to our home? What happens to our RSPs? Remember that if you die intestate, right, and you're in a de facto union, your spouse gets nothing. Everything devolves to the children. So I'll give you an example. There was someone who recently passed away in the community who was in a de facto union with his spouse. This individual had a son from a previous marriage. He was divorced from that woman. He was estranged from his son. The son did nothing for him during the time that he was ill. It was his wife who took care, but he didn't have a will. So when he passed, where does his property go? To the son. Not to his wife who took care of him, to the son from whom he was estranged. Those are the conundrums, because you could end up in a situation where you're disenfranchised unless you undertake these measures to protect yourself. All right. Cohabitation. Wills. Gotta have a will. Unlike married couples, common law partners do not automatically inherit. For a common law partner to be considered an heir, they must be named in a will. Otherwise, the property gets divided amongst your children, your siblings, other familial heirs, according to the rules of intestacy. A will is always important, but even more so in the case of de facto spouses. No will, no inheritance. Insurance policies also. De facto spouse doesn't inherit. You got to be named as a beneficiary under the policy. Certain issues involving children. So there are issues involving children that must be settled after breakup, who gets custody, what the rights of the parents are, visitation rights, child support. After a couple separates, both parents keep parental authority. That doesn't change. Parental authority is something that is innate to the parent-child relationship, and the state certainly doesn't interfere with that yet anyways. So they must continue to discuss these important issues and continue to make decisions based on the best interest of the child. The rules governing child support do not change, regardless of the marital regime or the de facto union. Child support is on its own, okay? So it really depends on who's more financially able to support the child after the separation. There is a model in place for child support payments in Quebec, and there are rules governing these and how much money has to be paid depending on who's making how much money, and it's a whole thing. But the important thing to remember is that whether you're in a de facto union or you're married, your child support obligations are not going to change based on whether or not you're a de facto union or you're married. A few words about Ontario. So we know now that in Quebec, de facto couples are not entitled to the benefits of spousal support, compensatory allowance, family patrimony. They would have to contract that under a cohabitation agreement. What's the situation in Ontario? A little better for common law spouses in Ontario. Why? Maybe no Roman Catholic Church. Maybe no centuries of culture that promotes marriage, that says it's a sin to live outside the bounds of marriage. It's really interesting. And if you look at the judicial philosophy and the history, and you can go on for, you can write papers on this, but it is a fascinating thing how the influence of religion can affect the day-to-day lives of couples in Quebec, even though the province now is more secular than it ever was, right? Ontario does recognize common law marriages. The Family Law Act in Ontario recognizes common law unions as a valid form of union between two people, providing that certain conditions are met. If two people have been living together for at least 3 years, or if they are in a relationship of some permanence and have a child together, then the law recognizes them as a common law couple. So couples who live together for less than 3 years are not otherwise considered legally married as a couple under the law. Now, Ontario says, well, common law relationships still have fewer rights and responsibilities than actual marriage, but they do extend certain rights, okay? So there are certain things, certain points, like tax filing status, property division, rights to spousal support payments, inheritance rules, benefits, divorce process. Let's look at each one briefly before we conclude. So tax filing, there are pros and cons to being in a common law relationship. The advantages from a tax perspective to being common law are that partners do not need to file joint tax returns and can claim more deductions than they otherwise would if they were married. You're claiming personal deductions, but on the other hand, because they're not technically considered married, they cannot take advantage of certain benefits that married couples can. For example, they're not eligible for spousal credits or other benefits that come from filing jointly. Child tax credits, for example, under the Child Tax Credit Act. So there are certain tax implications, advantages and disadvantages. Property law, for common law, there is no entitlement to the division of property. So that's like in Quebec, right? There's no entitlement as there would be in if they were married. So part 1 of the act, which provides for the equal division of financial gains made during a marriage, apply only to married couples. So this means that each common law partner is entitled to only what he or she brought into the relationship. So this isn't different. This is very similar to Quebec, I guess. And if two people have been living together for some time, the rule of thumb is that items purchased during the relationship belong to the person who paid for them, and items purchased jointly will be divided. So again, you can imagine what kind of a mess this is, to figure out who bought what and who owns what, right? And the home, the family home, again, the big area where you sink your money, treated like any other asset, right? So according to the property division laws in Ontario, that's sort of similar to Quebec. But for spousal support, they can make a claim, right? So a common law couple is entitled to spousal support. Remember 585 CCQ, right? So that wouldn't apply here in Ontario. If you satisfy the requirements of the Family Law Act, you've been living together for 3 years, you have a kid together, then you can qualify for spousal support payments. Inheritance, similar to Quebec, you got to have a will. You have to have a will if you're in a common law relationship. This is a little bit technical. You can make a dependency claim, unjust enrichment. Not going to get into that. There are certain rules governing Canada Pension Plan and old age security that you could benefit from. And there's no formal sort of divorce as a common law spouse because you were never married. So the big one is spousal support. If you've lived together for 3 years, you have a kid, you can claim spousal support even though you're not married. So you can see that the field, the area of family law, is complex. It's technical. It has all sorts of rules. And it's influenced by cultural factors, by your jurisdiction. But in Quebec, it's pretty homogenous in the sense that if you are not married, as a de facto spouse, you better take measures to protect yourself. Otherwise, if your union dissolves, you're going to walk away with nothing. So that is about 50 minutes, which is a time I wanted to spend talking about this. Now, if you have any questions, I'm happy to answer.
I would like to thank you so much, Alan, because it is more and more that couples are living together, and we always thought this would not happen to our children, but it is coming also in our community, and thank you for explaining so clearly everything.
Yeah, I hope I did. I mean, it's complicated. You know, it's a complicated area, and I know I'm throwing a lot of at you and a lot of legal terms and everything, but you know, if you come away with this idea that if you know someone in a common law relationship that you care about, tell them, you know, maybe it's a good idea to enter into a cohabitation agreement so that you, at the very least, you understand what your rights are in the event that your union dissolves.
I have a question.
Yeah.
I have a question. What if, and this might be like the kind of thing that gets to a court, like, I don't know. What if you've spent part of your life in Quebec and part of your life in another province? Do the rules apply wherever you die, basically?
Well, so if you're you know, if you're in a cohabitation, if you're in a de facto union.
Yeah.
And let's say you met in Quebec, you spent your time, you don't really have any rights here in Quebec as a de facto spouse. You go to Ontario and you're continuing your union, you live together and you're there for 3 years together or 5 years or whatever, you have kids. You don't have kids necessarily in Ontario, but you're living together in a relationship of permanence. I mean, it would make sense that Ontario law would apply if your residency is in Ontario. It seems to me that Ontario rules would apply, and in that case, you'd be entitled to claim spousal support.
Okay.
But again, these things tend to hinge on you know, one's assessment of the facts. And
I have a, oh, sorry.
Yeah, go ahead.
Have you finished? I'm so sorry. I can't hear
No,
you
go
all
ahead.
that well. I wanted to know if the same laws of Quebec or Ontario apply to same-sex couples who are married or who have lived together for a number of years. Sometimes they even have children.
Yeah.
So are there special laws for them? Are there, or do the same laws apply?
No, the same right now. I mean, you know, you know, a person's sexual orientation is a prohibited ground of discrimination under federal charter, under the provincial charters. You can't discriminate on the basis of sexual orientation. Gay marriage is legal in Canada. It has been for quite some time. So married couples who are gay are entitled to the same rights, obligations, benefits as straight couples. If they are married, and they are not entitled to any other additional benefits if they are not married. So, for example, the fact that you may have a de facto union between a gay couple does not entitle them to the benefits of marital regime protection because they are gay. They're treated as they would anyone else, as any other married couple.
Thank you.
There's another question in the chat from Orly. Can you file a cohabitation agreement at any point in the relationship or only at the beginning of a cohabitation?
No, you can actually file it at any time. You can enter into a cohabitation agreement at any time. And in fact, it happens more often than not that based on sort of, again, this is not my primary area of law, guys. This is really, I do my research and I read articles on this, but this is not my area of practice. I'm not a family lawyer. So if you have any questions, go to a family lawyer. Do not rely on this. This is not legal advice. This is just, my giving you a sort of a background on the issues. But very often, as couples, start to invest more into the relationship and there's a greater sense of permanence in the relationship, then things like a cohabitate and a greater mingling of assets, right? There's a greater need for these types of agreements. So very often, cohabitation agreements aren't entered at the inception of the relationship, when you don't really know the person, you don't know where it's going to go, but only later, when you've spent a lot of time, especially if you have a kid with the person. At that point, it starts to become really important. All right.
I wanted to know if
Yep.
do you foresee changes in the next couple of years, or is there pressure to change something or other in these laws?
It's a thoughtful question. I mean, I don't know if anything is really on tap, but this decision, when it came out, it sort of shocked the conscience of a lot of the province. Like, well, why should cohabitating couples not have the same rights? Why should these provisions of the Civil Code continue to apply? I don't know what sort of legislative sort of efforts went into changing the laws and making them more, for example, akin to what's recognizing, for example, at least the right to spousal support, right? I mean, at least spousal support, right? Shouldn't a woman or a man, shouldn't sound patriarchal, be entitled to something? If they're the ones who, spent their life sort of taking care of the family, rearing the family home, giving up their career, it sort of makes sense, right? It's sort of this arbitrary distinction. Well, why aren't you? But then the counter argument is, well, look, people are free to contract or enter into cohabitation agreement. People are free to get married. The institution of marriage should be respected, right? And there's a long history for that. Never mind that we allowed same-sex couples. That tradition we threw out the window. But we have certain standards, right? That no marriage, no spousal support. No marriage, no family patrimony. It profoundly affects people's obligations. Like, how would it work? Like, if you start enacting these laws, how would it work? Because if people have been in a cohabitation agreement, if people have been in a de facto union for 20 years, and then you change the laws, are you grandfathering those people? So if they split up, they're no longer, would they have to give spousal support, or they're no longer required? It's a complicated thing. It's a hard thing to change that. The answer is I really don't know, how much push there was after the fact. It's not something I really looked into. I just sort of was examining the cases. But I would imagine there's always sort of lobbying to change laws to make them more congruent with social realities.
I understand that this becomes quite complicated, mainly because of culture. And I assume abuse. And what I mean by that is, what if a couple is not living together, and then they claim that they are a couple, there are no children. I think it'd be very difficult to prove that they have been a couple for, you know, I don't know, a dozen years or whatever it is, 1 year, 3 years, whatever. So I can imagine that there could also be abuse of the situation and, you know, saying that you are a couple when you're not, or trying to prove that you are a couple if you are. So, I mean, it's very difficult.
It
It
would be.
also, you know, when we talk about the culture, yeah, it sounds almost silly to say you need to be married. On the other hand, it may be common law unions contribute to the breakdown of society. So it does get extremely complicated, I think.
Yeah, I mean, I don't know whether common law, I mean, look, it could be. I think there are other factors that contribute to the breakdown of society more.
I can't hear you, I'm sorry.
I think there are probably other factors that contribute to sort of the degeneration of society more than sort of common law.
Okay.
But I mean, I think it's part of it. It's certainly, look, marriage is the most sort of foundational. You know, marriage and the traditional family, I think, are very much at the root of so much evolution and success and happiness and all of these things. But, you know, the reality is that marriages dissolve all the time at a rate now, probably more than 50%. I'm lucky. I've been happily married for 25 years. I don't have any issues, but most people I know have gotten divorced.
Most people what?
Most people I know have gotten divorced or are not in the most blissful unions. So believe me. So I mean, I you know, I understand sort of the reluctance of a lot of people to marry, because once you marry, those family patrimony provisions kick in.
Mhm.
And you can't contract out of that. You can't get out of that.
Right.
And, you know, life is precarious and things change, and, you know, you want to retain your autonomy. I'm a big libertarian. I don't like government interference in my life. But I recognize the necessity for certain things, for the obligation of government to, you know, to uphold their end of the social contract. And I understand the need why these provisions, many of these family law provisions were enacted. Because, you know, historically, women who were divorced were ostracized, were left in a state of penury, were left indigent, were unable to earn, you know, so it's important that you have these sort of corrective legislative measures that were enacted over the years. The problem is, very often, and again, it depends on what your judicial philosophy is, the cure starts to end up becoming worse than the disease. So there's overreach, there's you know, sort of an involvement in the minutia of people's personal lives, where you take away freedoms that they may otherwise should have. So I don't think there's any easy answers, but that's the system we have, and take it or leave it. I mean, when I got married, and I always say this to people, if my wife had Bill Gates's money, I would still marry separatist to property.
You'd still marry what?
I would still marry separationist to property. And because it's not fair, you know, fundamentally, marriage should not be used as a vehicle to loot other people's wealth. And the only time that distinction between equests and separation of property starts to make a difference is if the marriage dissolves and you're on bad terms. Right? Because if the marriage is intact, it doesn't matter what marital regime you're under.
Right.
If the marriage dissolves and you're on good terms, which happens, you'll come to a mutual agreement as to how you divvy up the properties. But if the marriage dissolves and you're on bad terms, that's when it starts to make a difference. That's when you're going to say, no, this is mine, this is mine. She said, oh, that's mine, that's mine. And then you're going to have the clash. So right. I always say that, you know, under those circumstances, it makes sense to marry separationist of property, because at least you have a certain degree of autonomy over how your assets, over what you retain control over. Because the family patrimony stuff, that's getting pooled no matter what. So there are measures that you can take to protect yourself. This is in marriage, but much less so in Quebec. In Ontario, the situation was a little bit different, but even that evolved, right? There was a very famous case when Abella was on the Court of Appeal, where this woman, it was the marriage, it was really a seminal case. I can't remember, it was 20 years ago since I took a family law course, more 25 years ago. And this woman had married this very wealthy guy. And he had a very, very detailed, foolproof, tight marriage contract that if the marriage dissolves, this is what's going to happen. And it came before Abella, and she just basically ripped the contract apart. She said, no, this woman is getting much more than she would otherwise have been entitled to. And it had been a more sort of objective reading of the contract. But judges tend to oppose their version of what they feel is right, rather than sort of being a strict textualist and looking at the contract or looking at they find a way, right, to give a very broad meaning to things and to get the results that they want or that they think are correct.
Thank you.
Thank you so much, Alan, for
Okay.
giving of your time. Your time is very precious, and yet you offered us to join us and to give us all the explanation that we need. And
Yeah, I do it only for you, Gladys, because I know how hard you work and you're such a nice lady. And whenever you ask me, I can't say no. So I'm always happy to
thank you.
yeah, I don't know how much you're getting out of these presentations, but I'm happy to do it.
I really appreciate it very, very much. And as I said, we need these explanations now. A few years ago, nobody thought about it. But
yeah,
if our children got married legally, our grandchildren now are living together. And I don't see any marriage by now. So,
they want to protect themselves.
So this explanation, I'm not complaining. They do whatever is good for them, but this is the reality. And I appreciate so much, Alan.
You're welcome. You're most welcome.
Thank you. Really, thank you.
Have a good day, everyone.
For joining us.
Thank you very much.
Pleasure.
Thank
Okay.
you.